Good afternoon and welcome everyone. It's great to have you all with us. My name is Martin Tideström. I'm Director of Business Development at ADGM, and I'm very pleased to kick off the first in ADGM's 2020 webcast series. We are in unprecedented times. And before we get to business, I want to emphasize that ADGM and our community recognize those of you who have been impacted by the virus. Those of you who are not able to see your loved one, especially in this holy month of Ramadan, and those who worry about the future. We know that many do. We also know that many businesses across industries and sectors face challenges. Many struggle in the here and now, overcoming direct challenges from mobility restrictions, supply issues, changing demand, sustaining their revenues, winning work, getting paid, and controlling costs. Others, on the longer term, making the right choices for the future. And although no one knows how long the pandemic will last, its full economic implications, or how the world will look after recovery, most of the executives we speak with believe that business in their industries will be different, and they will need to change differently on challenges and opportunities. We are launching these webcasts to help dialogue on both the short and long perspective, drawing on the expertise of our many partners, aiming to share knowledge, thought leadership, help. Starting today, we have many good sessions lined up with business leaders, economists, bankers, strategy experts, lawyers and other advisors, and with senior government representatives. Topics will include, just to name a few, Abu Dhabi's new in-country value program with a webcast tomorrow, perspectives on the recession and what it will mean for business in the Middle East, business continuity planning, cash management, corporate debt restructuring, cybersecurity during Corona, and the stimulus packages Abu Dhabi is providing for its business community. We count on your help in this. Let us know what you want to hear about, and of course, if you have expertise to share. So today, our first topic, important for all, employment law in crisis. Giving, I hope, interesting perspective, reflecting both ADGM and federal emirate level legislation on angles such as health and safety, precautions during Corona, what options employers have, and what protection employees are ensured. It is a great pleasure to welcome our two experts. First, Fatima Al-Numeri of ADGM's Registration Authority. Second, Ivor McGettigan, partner of Al-Tamimi. We're going to go ahead this way. I will start with introducing, or rather having our dear speakers introducing themselves, a brief fireside chat with each of them, and then open up for questions. We know that many of you are following this via live streaming from ADGM's website, LinkedIn, YouTube, Twitter, Periscope. Our team is monitoring all channels and forwarding your questions to us, and let's make this a good dialogue. With that, Fatima.
Thank you very much, Martin, for that introduction. I would like to introduce myself, Fatma Ali Al-Numeri. I'm a senior legal specialist at the Registration Authority. Among my many duties, I oversee the operations of the Employment Affairs Office. And I am also a qualified public notary with the ADGM courts in a joint initiative with the Abu Dhabi Judicial Department. I would like to thank everyone for joining us and tuning in at 4 p.m. on Ramadan. I'm sure you're all very tired. So we will try to make this session as informative, as engaging, and as entertaining as possible. Thank you, and I'll pass on to Ivor now.
Thank you, Fatma. Ivor McGettigan. I'm an employment partner at Al-Tamimi & Company based in ADGM, and thanks to ADGM for arranging this webinar today. I'm really looking forward to a dynamic conversation with Martin and Fatma, and also the questions coming in from the live stream. So without further ado, over to you, Martin.
Great. So thank you both, Fatima and Ivor. Let's start with Fatima, you and ADGM. For those not familiar with ADGM and the special legal environment it presents, would you mind giving us an overview?
Yes, absolutely. Thank you, Martin. So the ADGM, as most of you know, is a financial free zone established in the heart of Abu Dhabi, pursuant to Abu Dhabi Law Number 4 of 2013. So what does that mean? To simplify it, the ADGM entities and their employees are exempt from the application of UAE civil and commercial laws. Instead, the ADGM is a common law jurisdiction. English common law is directly applied. Now, just as a brief, the ADGM is made up of 3 independent authorities. Firstly, there is the Registration Authority, which is responsible for the registration, incorporation, and licensing of legal entities in the ADGM. It also facilitates all government-related services for ADGM entities, for example, the facilitation of the issuance of visas and permits. Next, we have the Financial Services Regulatory Authority, which supports and facilitates all financial services in the ADGM. And last but not least, the ADGM Courts, which is a fully digitalized court platform that offers an independent common law framework distinct from the predominantly civil law jurisdictions in the region. The judges presiding over these cases come from some of the most respected common law jurisdictions globally. Over to you, Martin.
Great, thank you. And before we get into employment matters, I know that ADGM has taken many measures to support business in these difficult times. Could you tell us something about that?
Yes, absolutely. Now, it's inevitable that we're dealing with the current fallout of the pandemic. We, as the ADGM, have tried to do our part to assist ADGM businesses in coping with the unfortunate consequences of what has been going on globally. So in doing so, we have introduced a number of measures. Before I go into the measures, I would like to quote the Registration Authority CEO, Wahar bin Bahar. He was very clear in stating that we are committed to working with you, our clients and partners, in supporting you in any way that we can to weather these unprecedented times. So what does that mean? Very recently, in fact, the ADGM's board of directors has approved the introduction of new initiatives and incentives to help alleviate some of the pressures that have been caused by this unfortunate pandemic. So just to list a few of these incentives, there are more. To list a few, the first one includes 100% reduction of the commercial license renewal fees, and this incentive will be applicable until late March 2021. The next incentive is a 50% reduction of the fees for new applications. So for new entities looking to set up on the island, they will receive a 50% reduction of the total fee. This is going to be applicable until the 31st of December this year. And as another example of what the ADGM is offering is that now ADGM companies and LLPs, limited liability partnerships, can avail up to a 3-month extension for the filing of their annual accounts. How can you do this? You submit an application to the registrar explaining the reason of why you would need such an extension, and should the reason be sufficient, the registrar will grant such an extension. Now, we hope that many of you will benefit from these measures and other measures that have been introduced, and many of you will have questions. So please visit our dedicated COVID-19 support page for more information. Just to clarify that all the information that you will need, all the links that you will need to access this information will be shared with you after the session.
Great, thank you very much for that. Now to the topic we're all here for, employment. Now you lead Abu Dhabi's ADGM's Employment Affairs Office. Can you explain what that is and what are the key questions, the key concerns you address these days?
Absolutely. As a matter of fact, employment law is a passion of mine. Now, to move on to the topic that everyone has tuned in for, before I talk about the regulations, I want to briefly mention the Employment Affairs Office. And so the Employment Affairs Office has been established in 2017 under the ADGM Registration Authority. What is our main role? The Employment Affairs Office is here to provide guidance to employees and employers on the employment regulations. Especially in these difficult times, we're noticing that employees and employers need further information on what our regulations state, particularly because they're quite different than other employment laws. So what we do is provide guidance. Now, something I need to emphasize to everyone here is that our employment regulations set a minimum standard to govern the relationship between employers and employees. So what does that mean for you? What that means for you is that parties to an employment contract may choose to contract to terms that are more favorable to the employee. So let's say, for example, the employment regulations state that an employee is entitled to 20 business days of annual leave per year. The employer and employee may agree to more than that. Now, I would like to also bring up a very common query that has been addressed to the Employment Affairs Office. Seeing as the onshore laws, civil and commercial laws, are disapplied from the ADGM, and then very recently, the Ministry of Human Resources and Emiratization issued the ministerial resolution number 279. We got many queries as to whether this applies to ADGM entities or not. Now, generally speaking, this does not apply. However, and ADGM entities are not legally bound to adhere to the ministerial resolution. However, given the flexibility of the employment regulations, ADGM entities may mutually agree with their employees to similar terms. And the emphasis here is to mutually agree. I will go on to give you a few examples of how the ministerial resolution can be adopted or not adopted, but how similar measures can be implemented by ADGM entities. But before I go on to say that, I would like to say that we as the ADGM, especially in this very difficult time, aim to align ourselves with the UAE government. Now, the first and the most common query that is arising after the issuance of the ministerial resolution, which is unpaid leave. Can an employee say, can an employer force me as an employee to take unpaid leave? Now, the regulations are silent on this matter. However, should an employee and employer agree that a certain employee will be on unpaid leave for a specific duration, that should generally be okay. The next query that we receive is in regard to annual leave. The regulations state, now, in regard to annual leave, it's very clear in the regulations. It states that an employer may ask an employee to take annual leave for a certain period. However, the condition is that the employer provides the employee with 7 days written notice. And the last common query that is arising is in regard to the reduction of salaries. The question that many worry about is, can my employer reduce my salary? Or the question that comes from employers, can I reduce a certain employee's salary or all of them because my business isn't doing that well? The answer is, and to be very frank with you, it depends. The regulations state that an employer may not reduce an employee's salary without the agreement of the employee. Now, the regulation has other situations where you can reduce the salary, for example, by virtue of a court order, a court of competent jurisdiction. However, one of those options is that the employee agrees to such a reduction. So you see, many of the measures stated in the ministerial resolution are viable options for ADGM entities. And similar to the resolution, they may only be adopted by the consent of the employee. Now, there's one key difference I want to point out before I move on, is the ministerial resolution, and I'm talking in regard to the permanent reduction of salaries. The ministerial resolution stipulates that you will need to register the addendum to the employment contract with the Ministry of Labor. In the ADGM, there is no such requirement. There should be an amendment or something to evidence the reduction of salary and the employee's agreement to it. However, this does not need to be registered with the registration authority. Now, my last point before I go back to Ivor is in regard to the non-employee rules. Until last year, the ADGM employment regulations did not expressly deal with relationships other than a purely employee-employer relationship. And as we know, this isn't always the case. Now, prior to the amendment of our employment regulations, it could have been done. There's nothing prohibiting ADGM entities from engaging individuals that are not strictly categorized as employees. However, there was nothing governing the same. In 2019, we introduced the non-employees rules. You're going to ask me, who are non-employees? Non-employees, as an example, are secondees or interns, or even outsourced individuals. They do not fit the definition of an employee, and therefore the employment regulations would not generally apply to them. So in 2019, we introduced the non-employees rules, which coincidentally comes into effect today. And it comes into effect today to allow for the engagement of these non-employees. Now, as part of the registration authority's support measures, the fees for obtaining temporary work permit for these non-employees are waived until the 25th of March next year. My last important key point here is that the fee for obtaining the temporary work permit is waived, not the obligation. The ADGM entity is still obliged to obtain a temporary work permit for the non-employees they're engaging. However, the fee is going to be waived. Non-compliance with that obligation may attract a penalty. So I would steer clear from that. Thank you, and back to you, Martin.
Thank you, Fatima. If I can follow up on a question here that I think some of our listeners are already thinking of, and I actually have a question from the chat here that isn't in this particular case giving all the details, but going to the role of the employment office if employees, for example, are having challenges. The question is about staff not being paid. Is that something the Employment Affairs Office is helping, or what is the right venue if then, of course, this would fall under ADGM legislation?
Sorry, Martin, I didn't quite catch that. You mean if staff are not being paid?
Yes. Where is the right instance to turn to?
Okay, so just to clarify one point here, the Employment Affairs Office, unfortunately, does not deal with complaints. However, we do provide you with guidance on what the regulations state and what the obligations are and your entitlements are. However, if in certain instances where there is a clear non-compliance with the employment regulations, and the compensation rules that are subordinate legislation to the employment regulations stipulate that there is a specific requirement and a non-compliance with that requirement occurs, the entity will be liable to a fine of up to X amount. If this is the situation, then the registrar will have the authority to impose a fine for such non-compliance. However, when we're talking about salaries and non-payment of salaries and a non-compliance with the regulations in that regard, the ADGM courts is the competent dispute resolution forum for employees, not for individuals that fall under the non-employees rules. Now, while we're on the note of ADGM courts, I would like to let everyone know that the ADGM courts have very recently launched a pro bono scheme that enables ADGM-based individuals with limited financial means to seek legal advice on a pro bono basis. What does that mean? It means that it's at no cost. So such legal advice may be provided by volunteer lawyers, and it is in regard to a civil or commercial dispute or other legal issues, which also include employment-related issues that fall within the jurisdiction of the courts. Again, that fall within the jurisdiction of the courts. Generally, if there's a non-employment relationship, the jurisdiction may not always be ADGM courts. So it will, I'm not going to talk further about that. The lawyers giving you legal advice can advise you further.
Great,
And
thank you.
thank you, Martin. Just a concluding comment. I would like to clarify to everyone and emphasize that we as the ADGM are committed to assisting ADGM entities get through this unfortunate hurdle. And we sincerely hope that we all get past this unscathed. Thank you very much.
Thank you, Fatima. Now, Ivor, how are you today?
Very well, Martin. How's things?
Good, thank you. Good, thank you. Now, Ivor, you've been here in the region for many years, advising wide section of employers on the impacts from COVID-19. Can you give us a quick overview of what's happening out there across different sectors?
Sure, Martin. Look, firstly, I would like to say that the title of this webinar is actually perfect, Employment Law in Crisis, because employment law, not just in this region, but internationally, is ill-equipped to deal with what we're facing. I mean, there's very few countries that have an employment ecosystem, an employment law ecosystem that can handle this. And, a few months ago, nobody really spoke about words like furlough, extended unpaid leave, and now it's at the tip of everyone's tongue. So these are concepts that unfortunately have entered into mainstream. But when you look at other countries, for example, the UK, they have a huge wage subsidy program that's keeping these employment relationships going. But in fact, when you analyze it, there's not much of an employment relationship left for some of these entities. And it just shows you that the machinery wasn't there to deal with what we're facing. So our phone started to ring about 2 months ago. It feels about 2 years ago now, early March. I remember getting a call from a hospitality-based client in Abu Dhabi saying that, COVID-19 was going to write off 2020 for them, and it was time to start looking at measures that they could take. And some of the measures that Fatma mentioned there in relation to unpaid leave, salary cuts, and unfortunately beyond that, we're mooted. But one of the interesting things about ADGM, and it's probably only interesting to me, Fatma, and maybe Martin, because we're geeks. But what's really interesting about it is that, Fatma mentioned we have onshore, free zone, federal, Abu Dhabi, Dubai, this, that, and the other. That can be quite confusing to people, and we get that. There's a lot of different layers. So add that and multiply by 10 for ADGM. And I don't mean that in a criticism, but I mean that in a really interesting sphere, in that on the island of ADGM, we have ADGM entities that are subject to the ADGM employment law. We have entities that have seconded employees from onshore. So a lot of the retail units in Galleria Mall, the fast food outlets, those employees typically will be on an onshore visa. And thanks to this initiative today from ADGM with the launch of the new rules on non-employees, there's a mechanism now where that's recognized, and there's a particular process for those employees to get that recognition. We also actually have a third category on the island. We have some government-owned companies on the island that were established prior to the free zone being set up, in fact. So prior to 2013, there were a number of Abu Dhabi Inc. Companies on the island, and they're actually not subject to, some of them are not subject to ADGM law at all, and they're subject to onshore law, and in some cases, in fact, Abu Dhabi Human Resources law. So it's a very interesting petri dish within ADGM. But what is welcomed by employers, and Fatma mentioned it earlier, and I'm glad she said it, is that ADGM wants to go into lockstep with what the UAE is doing. So, thankfully, we don't have to pull our hair out too much trying to work out what the requirements are in ADGM, because in fact, they mirror significantly what's happening everywhere else, including Abu Dhabi Department of Economic Development, Abu Dhabi Department of Health, and the federal authority looking after the crisis management. So there's a similar raft of measures that one has to take into account. But it's been a challenging time for employers, both onshore and within all the free zone. And in relation to this Decree 279 issued by the Ministry of Labour, as Fatma said, it doesn't really apply within ADGM, except to some of those employees who are not subject to the ADGM law. But ultimately it was always open to an employer and an employee to agree terms like an unpaid leave. There's nothing in the law to prohibit that. It wasn't very common for obvious reasons. The only time you would see it really would be somebody taking a sabbatical, or going off to do a study program abroad. But ADGM regulations don't prevent us doing it. So it's a very common measure that a lot of employers have rolled out. And I know some employees are unhappy to be on unpaid leave, and I've seen a question coming in on the live feed there, Martin, about and Fatma answered it in relation to what can somebody do if they're on unpaid leave. Starting point for that question is, did they agree to go on unpaid leave? So I mean, if that particular person has signed an agreement to go on unpaid leave, or signed it electronically nowadays, obviously COVID-19, everyone's executing documents electronically, then the position is that they've agreed to that, and that would be recognized by the courts. Obviously, if it was unilaterally imposed on them, that can't be done, because as a principle of law, one party can't change a fundamental term of the contract without the other party's consent. There are a few exceptions to that, but not within ADGM. So going back to that person, I think that would be the question I would ask them to consider. Then going to unpaid leave, salary reduction, similar principle as unpaid leave, has to be by agreement, can't be done unilaterally. And look, we appreciate that for a lot of employees, the choice, let's be frank, for a lot of employees, it's probably a Hobson's choice between unpaid leave, salary cut versus worse fate, shall we say, due to the particular cash flow problem that the company is facing. And that's not something that's unique to the Middle East or the UAE or ADGM. That's worldwide. So every jurisdiction have these problems, particularly in Europe, and Europe is very strong employee protections. However, believe me, the same conversations are taking place in Dublin and London and Paris, whereby employees are given this choice, take a cut or unpaid leave versus perhaps a redundancy. So that's the position there, but happy to explore some of that, Mark.
Excellent, thank you. Now, restrictions, at least to some degree, are gradually lightening. We see more and more shops opening up, for example. Companies are starting to put people back in the office. Can you talk us through a little bit what health and safety considerations are important for employers staffing up their operations again?
Sure. And again, an area sometimes may be confusing. There's a lot of stuff being issued every day, be it from Dubai, Abu Dhabi, and then the federal authority that's looking after it. So, I get that can be confusing. Look, the Emirates have taken a different approach depending on the profile of the outbreak in there and that they're dealing with. And in relation to Abu Dhabi, the Abu Dhabi Department of Economic Development issued very clear guidance in relation to mandatory testing for mall employees. So anybody working in a mall, they cannot return to work without having passed a COVID-19 test. And then in relation to other workers, industrial, professional, etc., the DED said that they would encourage employers to have them all tested. So it's not mandatory. So within ADGM, they've mirrored that approach. So within the Galleria Mall, there is actually a testing unit set up there. So it's very convenient. And employees have to get tested there before they can work in the mall. In relation to other measures, ADGM have brought in a social distancing measure, whereby, again, identical really to the onshore position, whereby only 30% of employees can be physically present in the workplace at any one time. The other 70% are working remotely. So that mirrors the onshore position.
Is there any rights an employee have not returning to work? Or how is that considered?
Yeah, that's a thorny issue. Look, some employees are making it known in social media and otherwise that they're not coming back until there's a cure, which could take a few years. But look, the position is this: the employer decides how work is performed. It's not for the employee to decide how it gets performed. So if the employer has a preference that it's performed physically in the workplace, then the employee should respect that. Now, subject to, I would say, two caveats, Martin. One being that the employer is itself complying with ADGM regulations in relation to social distancing. So, and these other regulations for the mall employees. The employer isn't complying with that, and already has 50% of the employees in, and is saying to the other 50%, you need to come in. And clearly, that doesn't withstand any scrutiny. So that wouldn't be a reasonable request for an employer. And the second thing I would say is, and it's not an employment law issue, it's a HR issue, I suppose. But a lot of employees have genuine concerns about this. And to me, this is an issue that you sit down with employees and have a discussion with them, rather than waving a copy of employment law or quoting Ivor McGettigan saying you need to go back. To me, this is a genuine crisis, genuine concerns, and I think an employee deserves to be listened to and their fears taken on board. What a lot of our clients are doing is they're applying like a triage risk assessment, looking at their employees. If they have employees, for example, with respiratory problems, they're saying, you don't have to go back, you stay at home. And then, I mean, that's an easy example, but it's a bit more nuanced than that. But obviously, for some companies in ADGM, obviously in the retail space, you can't work remotely. For the likes of the professional services firms, they're probably business as usual, working remotely. So it really depends on the particular entity, Martin.
I think you touch upon something interesting here. I believe, well, certainly what we've spoken to, most employers, they care, of course, very much for their employees, and this is a very unfortunate situation for everyone involved. I know many of our clients, they try to avoid taking measures that are negative for their employees as far as they can, but obviously there are a balancing act when revenues are drying up. In your discussion with employers at the time, of the various options that they have, we have touched upon pay cuts, about unpaid leave, possibly even redundancies. Is there a order you see companies trying to take this? Is there a way of deferring decisions, negative decisions, as much as possible? What do you see being used right now?
Yeah, it's a good question. And look, the ministerial decree that we were talking about earlier envisaged a cascading mechanism whereby you start off with mandated annual leave. So as Fatma said, the employer can say to the employee, you need to go annual leave, burn up all your leave for 2020 now. And then after that, we'll look at unpaid leave, salary reduction, whatever else. That's what the ministerial decree envisaged. So a graduated slope. Frankly, by the time the employers come to us and have the conversation, unfortunately, in most cases, the cash flow doesn't allow that. In our experience, particularly if you're looking at hospitality and retail, that conversation is already redundant. They're not talking about gradually doing anything because their business model has just come to a shuddering halt. So in those cases, even if they had the best will in the world, I don't think for them that's possible. For other employers, I would say, Martin, that definitely, if they're not absolutely exposed to the C-19 like others, then they do try to do something to the employees. So it's a bit of a mixed bag, I suppose.
Good. I have a question here coming in from the live feed. I'll read it out to you. Realize that it's maybe not an ADGM call to make these decisions, but do you have any visibility or advice on what's going to happen with ADGM firms attempting to capture talent from offshore?
Do you want me to answer that? Or Padma?
I assume that might mean onshore. So is there a problem moving staff, for example, from companies under the local legal system into ADGM in this climate, or for that matter, when borders open, to bring in skill from other countries? Yeah,
two points on that, Martin. One is the immigration department have restricted, as we all know, the issuance of new visas for either residency or tourist purposes. But for people in the country, they can still move from employer to employer and from onshore to free zone. So there's no issue there. But But the question might also touch upon another initiative called the virtual labour market. So the Ministry of Labour, as per this decree that we keep talking about, set up what they call a virtual labour market. And in fairness to them, it was set up almost overnight, whereby if you're letting people go, then you can share their details with their consent on this virtual labour market, so that companies that want to hire people can access that system and do it that way. So I'm not sure whether the question might be touching on that, but certainly moving onshore to ADGM, no issue on that.
Excellent. Good. I notice activities picking up here across the various chats. I'm gonna shoot off more and more questions coming to you here. One, and it's an interesting one, is how likely are financial and service employers to encourage work from home post-COVID? And I think just based on my discussions, I see a mounting interest from companies to doing that. I think firms realize that it actually works quite well. Much of what we do can be done remotely today. It is a way, I think, of getting more efficiency out of a working day if you limit travel time, for example, or physical meetings. And of course, also a way in the long run to limit office costs. So I think there is interest from a lot of employers doing that. And I wouldn't be surprised if a fair amount of employees don't mind working from home to a larger extent than they do today. What's the law's position on this?
Yeah, look, it's a fascinating discussion topic, and it's happening everywhere, obviously. The issue in the UAE is quite interesting, because working from home was never legislated for. And in fact, onshore, the labour law was written in 1980. So, there was no remote working, there was no freelancing, hybrid working. All these concepts that we take for granted aren't covered onshore. And some of the things we talked about, interns, secondees, etc., they are partially covered, but it's not particularly fluid, shall we say. But under the immigration law of 1973, the obligation on the employer is that the employee carries out work at the licensed premises of the employer. So it envisages a static workforce working in, probably at that time, factories and industrial outlets. It doesn't envisage people moving around the place and working other than their company. Now, don't get me wrong, of course, we all know that happens. People were working remotely before COVID-19. But there is that legislative lacuna that might have to be looked at in order to move this conversation to the level that would make us all entirely comfortable with that.
Just to add on to what Ivor just said in regard to remote working, a point to make that currently how the employment regulations are drafted, and to second what Ivor stated, the remote working isn't exactly legislated for, and some people may see it as it's not really a viable option if the employer is looking for the employee to be permanently remote working. If the employee is, because in the definition of an employee, as per the regulations, one of the elements that need to be fulfilled is that the employee is ordinarily working within the ADGM. Mm-hmm. So if they're going to be permanently remote working, they're not going to fall within that definition. So, however, there may be talks of, I cannot comment on that at this moment, but I just need to point out that the definition is a bit limited to allowing it. So if the employee is working in the ADGM, however, as a matter of policy, the entity wants to allow them to take, let's say 2 days a week working from home, that will be a matter for the company to decide on with their employees.
Excellent. I have a couple of questions, I think, for you now, Fatima, referring to the ADGM regime. One is, and I think this is on top of the mind of quite a lot of people, does an employer have to maintain health insurance for employees? And would an employee have a right to repatriation flights after an term is up?
Yes, these are very good questions, Martin. In regard to your first question of health insurance cover, yes, the employer is required to maintain health insurance cover for their employee. even if the employee is on unpaid leave for a certain period. And in regard to your second question of repatriation flight entitlement, yes, upon term, this is a new introduction actually into our regulations, which have been introduced in the 2019 employment regulations. There is a requirement on an employer to repatriate the employee that's being terminated back to their home country, unless the employee obtains alternative sponsorship within 30 days after the termination, or the employee has been dismissed for cause. So, however, given the current circumstances and the halt of flights and the difficulty, and not just halt of flights, even difficulty entering another country, the employer and employee may wish to enter into an alternative arrangement. And this is going to be a contractual matter between the two parties. But yes, it is currently an obligation under the regulations.
Excellent. Another question, I don't know whoever you want to take that, and it's a positive one. Pregnant women, mothers, do they have rights or extended protection in these days?
Do you want me to take that, Fatma? Or will you?
Please.
Yeah. In relation to, there's an argument that under the ADGM anti-discrimination provisions, which are quite comprehensive, that pregnant women should be treated differently and protected, as otherwise it could be discrimination on the basis of gender. So certainly it'd be open to that argument. And in fact, going back to my earlier point about sort of triage and employers looking at their workforce, certainly in our experience, pregnant women would be one of them that they would be looking at and saying, you know what, you can work from home if it's within the realm of the operation to do that.
Excellent, thank you. I have a redundancy. We touched upon that a little while ago. I believe there's more to be said on the topic in this regard.
Yeah, look, I just, obviously it's a common principle and concept internationally, and I just wanted to mention that in the UAE, it doesn't actually. If you did a word search for the word redundancy in the UAE labour law, you wouldn't find it. And likewise, if you did it in the ADGM regulations, you wouldn't find it. So it's not for employers in certain countries, it's a full defence to an unfair dismissal claim. But in the UAE, that's not the case. So onshore courts, employers could be open to a claim for unfair dismissal, even if it's what we would otherwise say is a genuine redundancy scenario. Now, the employer can mount a defence and produce his books to the court to show that there was economic rationale for this and nobody was being singled out in particular, etc., etc. Within ADGM, there is no express compensation for unfair dismissal. So the ADGM regulations don't contain any heading. Nobody can point a heading and say, that's what I'm basing my claim for unfair dismissal on. So the rights for the employee in ADGM on a black letter of the law is the notice period, end of service gratuity, accrued benefits like annual leave, etc. And maybe just to circle back very briefly on end of service gratuity, because when we talk about reductions to salary and unpaid leave, that has an impact on end of service gratuity. If the salary reduction was made to the basic element of the remuneration package, so normally the remuneration package is 50 to 60% basic and the remainder is allowances. If for some reason that there was a cut made to the basic salary, that would have a disproportionate and unfair impact on the employee, because end of service gratuity is calculated on the final salary. So if that employee took a pay cut today to their basic salary and then was made redundant or terminated in the following week, and the employer said, well, we're going to calculate end of service gratuity based on your salary next week, obviously that'd be unfair on the employee. So there is a way to ring fence the end of service gratuity prior to the reduction. But in our experience, most employers try to, if they can, limit any reduction to the allowances element rather than the basic salary to avoid that sort of situation.
Excellent. I think we have covered most of the questions we've gotten into. There's one remaining question I want to put to you, and it might fall outside the scope of employment law, but unfortunately there are people losing their jobs or being caught in between jobs, unfortunately, in a market where it's challenging these days. Are there any good mechanisms, platforms, forums, support programs for people looking for work today that you're aware of?
Sorry, Ivor, I'll just answer first for in regard to the ADGM element of it, and then I'll pass on to Ivor. Currently, we don't have some kind of platform where employees that have been terminated can be listed, and then an employer looking to employ someone can look at this list, similar to what's happening onshore. But this isn't available at the moment. Please keep an eye out on our COVID-19 support measure page. If anything does change, that page is always up to date. It always contains the latest information, so you can find whatever you need on that site. But as of yet, not at the moment, no. Ivor, please.
Thanks, Fatma. Just anecdotally, 2 points. One, some employers provide career counseling type coaching service through a third-party company that specializes in that to their employees. And then on the other front, we mentioned the virtual labour market, which is what the Ministry of Labour has as another option. But again, anecdotally, I know a lot of people who have now said, well, look, the job environment's going to be pretty bleak for a while. I have skills and I have contacts. I'm going to set up my own business. So they're going off and now they can go to ADGM, get a freelancer visa, and then set up their own shop and do it that way.
Excellent, and I think you end this on a good note. Obviously, we are in hard times now, but the world is not coming to a stop. There are needs for good skills. There are opportunities, and as we alluded to in the beginning here, although the world will be a different one, there will obviously be chances. I think we have seen in our business community, especially on the entrepreneurial side, a lot of good companies with good ideas that are seeing more opportunities because we are engaging differently, because we're working differently, because demand is changing into new types of services, new types of products. I think you're right. There are ways of utilizing skills in different contexts going forward. I think we have come to an end of the questions we've gotten into. Are there any comments, any reflections, any advice you'd like to leave us with, Fatima?
Yes, I just want to add one comment that at the Employment Affairs Office, we remain available anytime to answer any query you may have in regard to the employment regulations. The email address will be shared after this session. So please do not hesitate. Let us know if you require any kind of guidance or clarification. Thank you very much for tuning in.
Thank you, Fatima. Ivor?
Just a comment. I want to send best wishes to everyone. It's a really difficult time for a lot of people that are tuning into this webinar, I'm sure. And Fatma's mentioned the pro bono clinic that ADGM have, and there are avenues for help. But just sending best wishes to everyone.
Thank you. Same from me. Thank you first, Fatima and Ivor. Very interesting discussion. Thank you to all of those of you who have been listening in and helped us with comments, suggestions. From ADGM to all of you, be safe. Thank you very much.
Thank you very much.
Thank you.